Please don't worry, it's not going to be a speech just because I'm at the podium. Mr. Prashant Bhushan, my distinguished colleague at the Supreme Court, Ms. Roshni Shankar, Ms. Cheryl, Professor Bora, dear students, ladies and gentlemen. First of all, permit me to thank you from the bottom of my heart for asking me to be in your midst today to discuss an issue of very significant importance in various contexts. I'm mindful of the fact that I'm here because, courtesy the petition filed by Prashant in the Supreme Court, I also had an opportunity to intervene in the matter of the Rohingyas' deportation, and that is how the interest in the whole problem of migration, refugees, asylum seekers came up front in our horizons. And courtesy the petition, courtesy the fundamental issues that have been raised before the Supreme Court, we are in a position today to discuss the specific issues in the much larger context of democracy and human rights. And in my opening remarks, that is precisely what I seek to do, to place in perspective the refugees' issues in the context of democracy and human rights. And since Roshni has had the great privilege of studying at Columbia, I'm reminded of what Professor Louis Henkin of the Columbia University has written. He has said that 21st century is the age of rights. And he's also said that it is the only, and I agree with him, he has said that it is the only moral and political idea of this century that has received universal acceptance. The integrality between democracy and human rights has been underscored by Ronald Dworkin. It has been underscored by many, many others who have now earned a place of pride for themselves through their writings as far as the evolution of the human rights jurisprudence is concerned. I would like to very briefly touch upon the broad architectural framework of the issue. When we went to the Supreme Court, and while I was in the process of preparing my intervention application and then finalizing written submissions, which at some point of time will have to be placed before the Supreme Court, I was struck by the opposition to the petition from the Government of India. I wasn't surprised, but I was struck by the crass insensitivity represented by a sovereign government representing a sovereign people, a government of a country which has on record a huge commitment to human rights. I am proud to be a citizen of a country whose Supreme Court, through an expansive interpretation, has placed the right to dignity, the right not to be tortured, the right not to be subjected to degradation, at the pinnacle in the hierarchy of human rights. I think since Maneka Gandhi in 1978, when the correlation between Article 14, 19 and 21 were established, we have had a series of landmark judgments. And I would recall to memory Puttaswamy in particular, whose scholarship has earned our Supreme Court judges universal appreciation, has reaffirmed that right to dignity is fundamental to every individual. It has nothing to do with citizenship at all. The moment we say that the basic right to dignity, including the basic fundamental political and civil rights, which, as Ronald Dawkins has very ably argued, must be conceded to every citizen of the world, to every individual, that is, no state can be heard to say that even though the factum of persecution, the factum of threat to life is established beyond doubt, we shall not discharge our humanitarian obligation. We shall not safeguard someone's life, whether it is a refugee's life or someone's dignity, including that of a refugee or an asylum seeker. That's the broad framework of the argument that is now being canvassed before the Supreme Court. So when I heard the law officer of the government stand up to say, he said two very, very, very strange things, very difficult for me to answer. I have great respect for my colleague. I guess he was duty bound to argue the case as he was instructed. And the arguments of the government were, A, that in the interests of the security of the state, we cannot allow these Rohingyas, a vast majority of whom are aged people, sick people, women and children. Now, a country of India's size, according to the law officer's statement in the Supreme Court, can be threatened by these hapless, helpless people running from their country to save their lives and that of their children and the elderly. I just cannot accept that this argument was made, and it was made in all seriousness. The second argument that was made was that the financial capacity of the Indian state cannot be strained for the sake of 40,000 Rohingyas, 16,000 of whom already have the UNHCR certification. Now, we are a country that waxes eloquent, and I think rightly so, that we are the sixth largest economy of the world with 2.3 trillion US dollars GDP. And we are counting pennies in order to defeat an otherwise indefeasible humanitarian obligation, a constitutional obligation that the Indian state has taken upon itself through Article 21. The issue, therefore, is, can there be democracy without human rights? Because democracy, at its core, is about equality, it is about dignity, it is about autonomy, as Puttasammy tells us, it is about the right of choice. And it is about basic values which are non-negotiable, as Aaron Barak has written very extensively in his classic book. And the argument that is now being made all over the world and has found almost universal acceptance is that there are certain values which, to make matters simpler in our context, are enshrined in our directive principles and in fundamental rights, that these are the defining values of our republic. These are not only the defining values of the republic, these are the defining values of the international treaties and instruments to which India is a signatory, including the Universal Declaration of Human Rights, and about 10 of those. Then there's a third argument, which will be argued, I'm sure, in the Supreme Court, but which I would like to point out here. The constitutional obligation under Article 51C, 1C of our Constitution, for India to bring its laws in conformity with its international obligations. Now, remarkably, what is being argued in the Supreme Court on the side of the government is that because India has not ratified the Refugee Convention of 1951 and the 1967 Protocol, India is not obliged by any international treaty or obligation to give refuge to the Rohingyas. This is a wholly misconceived argument in view of the fact that I have here before me, and I will presently read it out for your reference, at least 10 international instruments which India has signed and ratified, and by which India has declared itself to be bound, which clearly obliges it not to deny refuge, not to deny asylum to those who are fleeing persecution, who are fleeing ethnic genocide in their country. And these, of course, are Universal Declaration of Human Rights, International Covenant of Civil and Political Rights, Convention on the Rights of Child, International Convention for Protection of All Persons from Enforced Disappearance, the United Nations Convention Against Torture, the Bangkok Principles, the New York Declaration of as late as 2016, the Bali Declaration is also 2016, and two very, very significant legal opinions rendered by UNHCR and by the International Court of Justice, which clearly say that even if a country is not signatory to the Refugee Convention, the right of asylum is a part of jus cogens, it is a part of internationally customary law, it is binding on all states parties to the UN Charter. This is an established proposition. My painful duty today is to point out that this should have been an unconscionable argument for the government of India to advance. Now, the UNHCR advisory opinion on the extraterritorial application of the non-reforma principle clearly says non-reforma obligations under international human rights law constitute a rule of customary international law. As such, it is binding on all states, including those which have not yet become a party to the 1951 Convention or the 1967 Protocol. You couldn't get it clearer than this. It's a decisive opinion whose principle, whose spirit, whose express statement must bind in India, because India is a part of the UN system. Now, the complementarity between international humanitarian law and the international refugee law has also been accepted in the advisory opinion of the International Court of Justice concerning the legal consequences of the construction of a wall in the occupied Palestinian territory. This was as early as July 2004, where the International Court of Justice said that the integrality between the international humanitarian law, represented by the 8 or 9 or 10 conventions that I read out to you, and the refugee law is now an established principle. So merely because of the technicality of India not having ratified the 1951 Refugee Convention, it cannot run away from obligations binding upon it by virtue of these 10 other international instruments. So all in all, Article 21, the international obligations that India is bound to respect under Article 51C of its constitution, and the various international treaties and obligations that I read out, which India has signed and ratified, oblige India to give refuge not only to the Rohingyas, but to all those who seek refuge against persecution, against threat to life, against threat to human dignity. Within this framework, there are, of course, many, many larger issues. But what I would like to commend this distinguished audience to reflect on further is the larger framework of the decline of democracy wherever we witness a decline of human rights. So the integrality between a human rights regime and a vibrant democracy demands that we construe constitutional guarantees and international humanitarian obligations expensively and lean in favor of interpretations that advance human rights in a world increasingly troubled by totalitarian and dictatorial tendencies that we see emerging and surfacing even amongst the civilized democracies of the world. So the challenge of our times, ladies and gentlemen, is to consolidate the human rights regime, to expand it and extend it in areas where people do not have its benefit. Thank you very much for your attention.
Thank you so much, sir. I think it was, I couldn't have put it better. Like, I think the legal arguments that were advanced, I think sir has summarized it in the most accurate way possible. And I think it was a surprise for all of us, because when the petition was filed and it was reported in the news, we were so confident because we had come from a UNHCR school of thought where non-refoulement was of course it was customary international law, and how could somebody challenge that? And the first day in court when the government said that, we are not bound by non-refoulement, it was the first time we were sort of faced with this situation. We were like, how can that ever be? And it was ironical because around the same time, as sir pointed out, the government, the MEA was making statements in Geneva as a member of UNHCR's executive committee, saying that non-refoulement should never be diluted, and yes, yeah, and that it should not be diluted, and there shouldn't be, you shouldn't confuse illegal immigrants with refugees. So it was a very strange situation to be in at that time. But thank you so much, sir. I now request Professor Bura to give us an academic viewpoint on the issue.
Thank you very much, Ms. Roshni. Yes, I'll try to focus a bit on some of the issues which were raised in the first session with regard to international law, and specifically the 1951 Refugee Convention. And of course, continuing on Dr. Ashwini Kumar's views on some of those which are accurately presented, but there are some of the details which one has to get into when we look at the international law, specifically the 51 Convention, vis-a-vis India's position, specifically as to why some of the questions were raised in the morning session as to why India doesn't want to become a party to the 51 Convention. When we discuss the refugee issue, invariably probably we need to get into it, one has to take into consideration the international dimension of the refugee situation, in the sense that it essentially is a matter of more than one state, because people move from one country to the other. The moment that situation arises, one has to deal with the questions of international law issues. Now, when we look at the 51 Convention, which is primarily the international law that governs the movement of people, especially asylum seekers, it needs to be somewhere contextualized in the global political situation, which was pointed out in the morning also, as rightly pointed out one of the speakers, is that most of the discussion with regard to refugees, it is true, takes place in the global north, or as global north as the center. Now, that is where the 51 Convention has to be looked at it. There are several writings with regard to the critical analysis of the 51 Convention. But one factor which cannot be completely ruled out is that its historical origins in the European context of the post-Second World War situation. Now, if you look at the Convention framework, now people have extensively worked on it, there are several gaps which in fact probably are the gaps if you look at from the developing countries' point of view, but that were not the issues in 1951 when the Second World War was over. So therefore, if you look at it, in fact, somebody was writing that the idea of refugees being kept in camps was not the idea in 1951, because the general idea was that if refugees were spread across entire Europe, probably they need to be either resettled, or probably they would be settling there. So there was no idea of keeping refugees in camps the way we now look at it at several places in Africa and other places, which is a very peculiar situation. And the other dimension of the convention is also that primarily it focuses on a kind of an individual refugee status determination process, which is individual is central to it. But most of the refugee movement which takes place now is in large numbers. In fact, there is how the determination which really has to take place. Now, that is one dimension with regard to the legal aspects which are involved in it. But the larger political scenario was that the 51 Convention in many respects served the global north or the first world in many ways, in a political sense. One is in an economic sense of reconstructing the Europe with the cheap labor, which they could invite laborers from across the world. That was one dimension. But the other one is more a very political one, was in fact looking at the second world, that was the erstwhile Soviet Union or Eastern Europe, and projecting the Western Europe as more of a free country, inviting large number of people from those who are fleeing the erstwhile communist countries. So it was also a kind of a political situation which in many respects benefited the larger political global politics that were taking place, and the Refugee Convention was one of the important instruments through which international legal framework the Western discourse was happening with regard to the 51 Convention. Then what has changed? Why is it that the same thing cannot happen now? Means that the way West has invited refugees, it could do that in a similar manner now also, because it would be serving a particular political discourse or interest. Probably I think things have changed in certain respects. One is in terms of the economic aspects of their own labor market is getting exhausted. The other is the end of the Cold War, where it was not really, it no longer serves the purpose of like inviting refugees from the West, from the Eastern Bloc, that is the Soviet Union, erstwhile Soviet Union. And so in that sense, it does not really serve the purpose, larger political purpose of it. The other is that, but yes, law is there, the 51 Convention protocol are there. How do you dilute it? So you do not dilute the convention, the legal obligations, but you can dilute